Hi. Again, I'm 𝗂𝗏𝗧𝗃. I teach at Rutgers Law School in Camden, New Jersey. And for some reason, I thought that the people, that y'all who are taking this course, might be interested in exams and grades in law school. I can't imagine why, but I think that you might be. So I want to talk a little bit about exams, about preparation for exams, a little bit especially about torts, and then and while I'm doing, talk about exam questions and such. Okay, law school exams. How are they different from undergraduate exams? Well, actually, some of them aren't too different. Sometimes professors might ask multiple choice questions or short answer questions designed to test specific knowledge. But that's not what the sort of classical law school exam is about. In your undergraduate exam, the professor will say, tell me what you know about this. In a law school exam, and again, there are some questions like that in law school exams, but very often what they're going to do is you have to figure out what they want you to tell them about before you tell them. And that's part of what law school is supposed to be about, actually. That it's not only about, I think students sometimes think of what law school is about as learning one rule at a time. And it is about that, there's no question. It is absolutely indispensable to know all the rules, that's your basic thing. But in theory, what law school is about is that you're supposed to be about learning about figuring out what rule applies and applying that rule to a particular fact situation. And law school exam questions are very often like that. They will give you a fact situation, and you have to figure out which rule you're supposed to use, and then talk about how that rule applies to these particular facts. The only thing that I can think of as analogy, even though I'm not a math major or anything like that, is I think some math exams are like that. That they'll give you a problem and you have to figure out how to solve the problem. Law school exams are like that. Very often they're like that. They have to be. And even the ones that look sort of like undergraduate exams sometimes, that they'll ask you to do something like figure out where the problem is in the statement. That I will ask my students to evaluate the accuracy of the following statement. And I have a hint for you if you ever get a question like that. The answer isn't, this statement is true. That part of that what you have to do, and this is again part of the whole thing of law school exams, is try and game it a little bit. And so you know that there's some problem with it. You just have to figure out what the problem is. Because I wouldn't ask you a question, this statement is true. Right? All right. I'm sorry, one more thing about law school that each of your courses. Law school is cumulative. Let me compare this to a history course, all right? Now I did a lot of Russian history when I was in college. Then I realized I couldn't make a living at that. And I knew that between Ivan the Great and Ivan the Terrible was 𝗂𝘅ily the Obscure as a czar, right? Now, if I had missed the fact of who 𝗂𝘅ily was, it didn't keep me from learning who the two Ivans were, right? Whereas law school is cumulative. If you don't understand what happens in the first week, you're likely not to understand what happens in the second week, even if you can understand, even if independently you can learn what happens. It's just cumulative. And so now you ask, what does this have to do with exams? What it has to do with exams is that you have to build up toward what you can't be, okay, let's go out on Friday night, let's go drinking 3 nights a week for 8 weeks during law school, and then 3 days before the exam, I'm going to learn everything that I need to learn. It doesn't work that way. The most important part of your preparation for exams is what you do during the semester. You read your cases, right? Read the material. Read the manual. You read the cases and you brief the cases. Why do you brief the cases as you go along? As you brief the cases, it helps you learn this necessary skill, both as a lawyer and for taking exams, of trying to pull out what is significant from the cases, right? Learning to read carefully. Learning to, trust me, as somebody who's written some of these exam questions, you need to read them carefully, and you need to read your cases carefully. So you start out, you read your cases, you brief the cases. You know, people brief principal cases, note cases, I don't know. Maybe they print the introduction, they brief the introduction from the book, but you have to brief the cases and get prepared for class. Read the cases really closely. So you go to class and you participate in class. I know you think your friends, who's the person you hate? The person who's there waving his hand all the time. Now, being on the other side of the lectern, it's partially, there are some students, it's like, oh no, X is waving their hand. Or sometimes, thank God, when I get to X, when I get to a real problem, I can call on X. But you need to participate, and even if you don't feel comfortable or don't want to be the person who says, there was a character in comic strip Doonesbury a long time ago, you would have to be very old to remember this, but one of the earlier characters was going in law school, and there was another person who was much hated, who would wave his hand and answer a question from the professor, and then pound on the table and yell, "By God, I love the law." You don't need to be that person, right? But you need to participate in class, and even if you're not participating out loud, you need to be thinking along with the professor, because the part of the theme of this is you need to learn everything you can about your professor, everything. Got pictures? Good. But and the other thing about learning this as you go along in class, it really is true that there is no such thing as a stupid question, right? Now let me tell you that I will be standing there holding forth on whatever. And it makes perfect sense to me because, not only did I have a long night the night before, but it makes perfect sense to me because I've been doing this for, I know I'm getting old because I'm doing this for longer than most of my students have been alive now. Meanwhile, you're sitting there and you have no idea what I'm saying, right? No freaking idea at all. And the people are sitting next to you busily typing away on their laptops. Want to know how old I am? People they used to be writing on legal pads. Now they're typing away on laptops. And they're saying, and the person left of you and writing, typing away on the laptop, nodding their head, nodding their head, nodding their head. And you're thinking, everybody else is getting this. I must be really stupid. I'm not going to raise my hand and show how stupid I am, right? And I'm telling you, the person on your right is looking at the Maxim website, but the person on the left is typing away, and what he's typing away is, I don't get a word this idiot is saying, but I'm going to type it all down in the hope that maybe it'll make some sense when I do it. Point is, ask the question. That's how you ask the question. If the professor hopefully will not make, most people don't make fun of you now. But it's up to the professor to say, maybe, look, I want to move on now. We'll talk about that later. But maybe the point is, if you don't understand it, there's some other person who doesn't understand it either. There's a famous joke in Justice Holmes, and the punchline is, if you don't understand it, some other damn fool won't understand it either. But that's, so, participate. Study groups. Always good to have people to share ideas with, commiserate with, get a different perspective on what's going on, help you with, trade ideas with, get a different perspective, maybe be able to explain something. Don't wait till the end of the semester to review everything you've done. I think that you will find that there are a lot of different concepts in law school, and they're coming at you at really fast. So if you're better off at the end of each section to take some time to look at your briefs, to outline that section, because outlines are good too. Outlining is like briefing a large section of the course, right? You're learning the material as you go along. You're figuring out what's important, what's not. So do it at the end of each section, every week or two. That's, it'll help at the end because you won't be, I think you will find that you'll have a much better grasp of the material. Take practice exams, right? Certainly at the law school that I'm at, and I think many law schools now, have files of old exams. And here's another theme. You can not only you're learning everything you can about your particular course, you're learning everything you can about particular professors. Your particular professor. Because of the nature of the law school exams, because many of them know not objective answers, different professors look for different things as they grade exams. If you're really lucky, there'll be not only exam questions, there'll be sample answers on the exams on the internet or wherever, maybe even on paper in the library. If you have problems with what's going on, make an appointment with your professor. That's why we get paid the not so big bucks, right? But that's our job. You should know. Now, let me just say, I've had some students who are a real pain in the butt. I'm not going to lie to you. But I don't consider a student who's a real pain in the butt a person who calls me up, asks for an appointment, sends me an email. I'm sorry, we don't call up anymore. We send people emails. Makes an appointment, comes to the appointment on time, knows what the questions that they want to ask are, has genuine issues with what's happened, and actually listens to what I tell them. That's not the definition of a pain in the butt. Yeah, if you're there 3 times a week and whatever, that could be a pain in the butt. But just don't be afraid to talk to the professor, because again, 2 themes about exams. Learn the material. Actually, there's 2. Learn the material, figure out how to write exams, learn the professor. Those are the 3 things, right? Try and find out what that particular professor emphasizes. Look at old exam questions. There are first things, there are a variety of different kinds of exams. They'll tell you about, there's multiple choice exams, there's short answer exams, there's standard law school exam questions, with the hypothetical fact situations. And then there is the dreaded policy question. Tell me what you think the best rule is for design defects, or whether you like the 2nd restatement or the 3rd restatement, and tell me why that rule is better. The best way to figure out how to answer questions like that, if your professor asks questions like that? Find a law review article that your professor wrote about that subject, if they did. Read the law review article and just regurgitate it. Now, most people are a little more subtle than that. But frankly, as I look at not me because I'm perfect, but as I look at some people's exams and know what they've said, I know what they're looking for. If you're at XYZ, conservative Christian law school, and argue that the Constitution requires the recognition of gay marriage, I'm not sure about that one if it's a policy question. But conversely, if you're at progressive view and argue that it doesn't, same situation, right? So, find out what he emphasizes. Review the material, take practice questions, but in reviewing the material, there is no substitute for having a complete grasp of the doctrine before you try to figure out how to apply it, right? And when I say have a complete grasp of the doctrine, here's one of the traps of law school. I know when I give standard, that part of my exam, when I give standard hypothetical fact situations, open the book, open notes, open internet, bring in the other fool professor, I don't care. Guess what? Most of your exam questions are time pressure And if you're trying to figure out what the law is during a 4-hour exam, good luck. You need to prepare for every exam as if it was a closed book exam, even if it's an open book exam. Doesn't mean you're not going to double check your understandings. And indeed, if it's an open book exam, you need to have your notes completely organized and easily accessible in a way that, whatever way works for you. But you have to remember about that, because I remember, these sorts of things that happen about not having notes organized. That I remember my property exam, there was a question about water law. I had written out all of the rules about water law in my notebook. Again, that was before the internet was on parchment. And I forgot that they were there. So they have to be organized, and you have to be able to quickly find things. So prepare as if it's closed book, but make sure you have your materials easily accessible. Okay. Relax the night before. Here I sort of hesitate, because different people have different styles about this. But whatever it is that helps you be ready that day, for most people, I think relaxing the night before, have a glass of wine, whatever, have a good night's sleep, no substitute for that. You should know it before the night before. But hey, if it works for you to study through the night, I don't want to fight with you about working with it, but that's okay. Now you get there and you get to the question. Remember, the issue is you have to find the issues. Read the question. Read it again. Make sure that you understand everything in the question, and you need to have some sort of rubric to spot the issues in the question. Let me tell you what doesn't work, and I know this from experience. The inspiration theory of answering law school exam questions. The inspiration theory goes like this. You read the question one time, and it inspires you to write about something. So you write about it. And once you start writing about the answer to the question, you get attached to what you're writing about. It's human nature, right? It's human nature that you start getting it, because you don't want to be wrong. So when I took contracts, I don't know how much of you looked at this, but contracts, maybe the fundamental point about contracts is the question about consideration. Did I give you any money to do what you were supposed to do? Consideration, right? Normally you don't have a binding contract unless there's consideration. Very basic point. I had my contract, I had an 8-hour take-home in contracts. 8-hour take-home, sometime in the middle of May. 3 o'clock in the morning, in the middle of June, I sat up straight and realized I never mentioned the word consideration on my 8-hour contract exam. Let me tell you, I did not get a particularly good grade in contracts. And the reason I tell that story, because the reason I made that mistake is because I wrote on the inspiration theory. Even though I had 8 hours, I read the question, I said, I know what this question's about, and just started writing about it. Don't do that. Now, read it again. Some sort of rubric. A couple of different ideas about that. One thing is that what some people say is you should think about every fact in the question and ask why it is there. Because I'll talk about in general and specific about constructing questions in just a couple of minutes, but these questions are usually fairly carefully constructed. And there may be red herring facts in there, but there may not. Talking about dates, numbers, things like that. Who did what to whom, and who else did what to whom in a different way. You need to think about some people say the best way to do this systematic issue spotting is to think about each of the facts one at a time and ask yourself why it's there. Another thing people do for an open book exam, they will take the table of contents of the material that you have covered in the course and ask themselves consciously, is this particular subheading there? Is this particular subheading there? Is this particular subheading there? Again, there are a variety of different systems about this, but you need some way to do issue spotting, okay? Another thing which doesn't work, a lot of examples which don't work. This is what I describe, and again, this shows my age. You may have heard of this person because I know all the music is on the internet. It's the Stephen Stills theory of taking law school exams. Stephen Stills was a member of the supergroup Crosby, Stills, Nash, and Young, well then Crosby, Stills, Nash, which first got together at Woodstock. You may have heard of Woodstock, yeah, far out, man. And then and right now he's like me, he's an old bald fat guy. But after he left Crosby, Stills, and Nash and Young, and went out, did a solo career on his own. He was with Buffalo Springfield, I think, before and then after. He had a song, a pre-AIDS song, called If You Can't Be With the One You Love, Love the One You're With. Now, some people have that theory about taking law school exams. And it goes something like this. Gee, I really don't know what this question is about. So I'll write about something I do know about. Usually doesn't work, right? Usually doesn't work. Again, this gets back to knowing your professors. Sometimes it works, but doesn't work usually. This gets back to knowing your professors, by the way, about how they grade exams. Some people will give maximum credit for really focused answers, even if they're a small part of the exam. Some people want you to see so I give maximum credit for seeing more of the issues, even if they're not as well developed. But you have to see all the issues, right? So you read the questions, but even if there are people who want you to see all the issues, again, by reading again, thinking about your answer, at least having some form of outlining your answer in your head, you will still, because you are, again, there are these time constraints. You feel like I have to start writing now. Trust me, you will do better in the long run if you take a deep breath, take 5 minutes out of every hour, 10 minutes out of every hour, organize your exam answer first. Now, let me take a slight detour here about another trap. There are these sadists among law school professors who think they are doing their students a favor by giving 24 or 48-hour take-home exams, right? You will no doubt, even 8 hours is too long in my view. I don't want to read all that crap anyway. No, that they're going to give you, and what happens to people at these 24-hour and 48-hour exams is they stay up the whole time, 24 hours, 48 hours, whatever. Now let me just say something about something I just mumbled. I guarantee you that even if they don't give they'll have a page or word limit generally about this, but even if they don't, I assure you that they do not want to read everything that you can write in 24 hours. They don't want to do that. Parentheses. There's only a couple of things about this job I hate. Grading papers is one of them. I've been known to stand up from the dining room table and start screaming when I read the answers to some of these things. So if you do have a 24 or 48-hour take-home, do yourself a favor, sleep for a few hours. You'll write a better exam question, right? Okay. I wish I had a blackboard up here, but I'd like to talk a minute now in terms of another thing about answering questions. You need to realize how a well-organized law school exam, how it is constructed in general terms first. And it has to do with this issue spotting thing. So I want you to imagine what one of my colleagues described as I was talking to some of the students at my law school about exam taking as the reverse chicken foot. You have to think about it as being on a blackboard. I don't have a blackboard here, sorry. But this is the way a good law school exam is constructed. That you start off here, right? And then you move down through the facts and you come to a fork in the road. That it might be yes and it might be no. Okay? If the answer to the question is yes, that's the end of the answer, right? If the answer to the question is no, it leads you to another fork in the road with yes, no. Again, yes ends it there, no splits off. What does that mean about the way that you answer questions? Let me give you a hint, something really technical and sophisticated. However I grade papers, however I grade them, whether it's me, person who's writing the 48-hour take-home, person who has different theory about what counts more than other people count, other counts, I cannot grade what's not on the paper. So if it's debatable and it says yes and then ends, you'd also need to write about, okay, assume though that it's no, and go down that road and see how that forks. Because otherwise, all that no stuff, and these are deliberately structured this way so these forks are general. Sometimes they're obvious, but sometimes they're debatable. They are deliberately structured so they can be, and I can have no idea about whether you have any clue about what happens if it's no, unless you write it down on the piece of paper or type it up into the internet or whatever it is people do. 10 years you'll just sending your exams telepathically. 10 years I'll be drooling anyway, it won't make a difference. But so you have to think about that in the way you're answering questions. And what else do you have to think about? As part of this same theme about I can only grade what's on the paper. Begin at the beginning, go to the end. Duh. Now, what do I mean by that? No matter how people are grading. This is back to this issue, rule, analysis, conclusion thing, right? Some people write it just that way. You can talk to your professor about whether they want to organize that. Do you want to have this sort of, it's almost tabular, right? Issue, rule, or do they want you to write it in pure essay form? But however you write it, right? That you need to begin by giving the general rule of law. This is basic standard argumentation, not only in law school, but in the world, which is you argue from the general to the specific. You argue from the general to the specific. So after you have found an issue, after you've identified an issue, you start by stating the relevant rule of law, the big rule of law. And you move down from there, right? You start by stating the rule of law and then explain, this is something students don't do. So most students have got that you need to state the rule of law, but then, again, no matter how it's graded, the really best exams, even the very good exams, will describe in some detail how the specific facts in this hypothetical apply to this rule of law, or how the rule of law applies to these specific facts. Now, which brings us to still another point. What if you don't know what the rule of law is? Unfortunately, we have in the United States of America the federal system, right? I'm not saying if you don't know it, I mean, if you haven't prepared and don't know it, you're going to be, this gets back to if you don't know the rules of law, you're going to be lost, no matter how good your technique is. But sometimes, you have, many times, you have different rules of law in different states, and you may have looked at different rules of law One of my courses I teach in conflict of laws, and there are 50. Hopefully, your professor will give you some sort of presumptions about, they might talk about the second restatement rule, third restatement rule, whatever. But if they don't do that, and if you've looked at 2 or 3 different rules of law in the course applying to the same fact situation, you should say, if it's this rule of law, it applies this way. If that rule of law, it applies that way, right? You need to be aware of those kinds of situations. Again, it depends, but this gets back to, but this all circles, a lot of these things circle back to read the question. You need to read the question in part to find out if he's given you any presumptions about that. You need to read the instructions of the exam first. I mean, I've had students screw up based upon, oh, I thought I had 2 hours and 45 minutes. Oops, the instructions said I only had 2.5 hours. I have to say I'm a hard ass about that. Person's 15 minutes late, I don't read the last question, but just because I don't think it's fair. But the point is, you need to understand that I keep going back to this theme because it's so important that unless you know what the question is, unless you know what the rules are, unless you know all of those things, you have no chance. I mean, you may have a chance, but you have sort of the random chance because you're sort of guessing about what you have to do and what's expected. You might think, one of the things you might think about here, might wonder about is, where do these crazy exam questions come from? Because that gives you some insight into, let me tell you about something, about teaching. Let me tell you about what a tough job I have. God, I could be worse. I could be working for a living. But the first 2 years you teach a course, you have trouble writing exams because you really don't understand the course that well, most people. The next 3 years, you're in sort of a sweet spot, right? Because you have just sort of ideas that have occurred to you if you've been reading through the casebook about where the exams come from. After that, well, here's an example of how a question about where one of my torts questions came this year. My mother, my 89-year-old mother, is in an assisted living facility. Before she was in the assisted living facility, we were in a sort of in an interregnum at the end of where she was in independent living. The way we were trying to maintain her in independent living was to have people come in. We would have people come in. And my mother was kind of ornery. And she told the people to stop coming in. Only the people who were told, we were, one of my brothers was in charge of dealing with the, his tort is being an idiot. But he was in charge of running this particular part of the operation. And the people stopped sending the people to my mother's house, but never told my brother. And nothing bad happened in particular. But I thought, suppose that they told us that we told her, we really need people to come in to make sure she takes her medication and this, that, and the other thing. And then they stopped coming in without telling my brother, and something bad happened to my mother. So I was able to write, it was a great exam question, She didn't take her medication, she fell and broke her hip, they didn't come in that day, she got bitten by a mouse, it was cool. Trust me. Anything bad happens, law professors think it's cool. Best thing for conflict of laws, we love mass plane crashes, for example. Cool. But the point is, you might get a fact situation that's coming from something like that. You might get another year I got a fact situation, I was inspired, inspiration theory, that because I read about a boat capsizing. I thought, cool, boat capsizing, all sorts of torts there. But this is the point. I mean, part of the point about this, aside from, and then and if you think about it, what I'm doing is the reverse of what I'm asking you to do, right? You have to take issues out of a fact situation. I'm trying to take issues put issues into the fact situation to create that reverse chicken foot, right? So, but part of the moral of that story is you have no idea. The point about having a rubric and having a systematic approach which will help you analyze virtually every kind of question is you're going to get whacked out fact situations from everywhere. And by the way, here's something I no longer do that some people think is clever. You know, they'll put in names from Humphrey Bogart movies. They'll make puns about my constitutional law teacher, something, again, you have to be old to understand this, but my constitutional law teacher wrote a question, and the punchline was, they'll put questions that have punchlines, the punchline was, it was the last tango in Paris. I mean, I know, that drives students nuts, but you have to ignore all that crap as well. Know your material, have a system, work the system, and ignore all the extraneous noise. That's the key to all, and whacked out fact situations are part of the extraneous noise. And again, this gets back to, and again, I'm going back to this because it's also very important. Know your material and go back to everything, do everything that you can do to know your professor, know what they're looking for, know what kinds of questions they've asked in the past. And if they haven't, there aren't, you know something? There is nothing wrong with asking the professor. They'll give you general terms. If they don't, ask them, right? So, and if you do all of those things, you will get all A's. And when Elena Kagan dies, you will be on the Supreme Court.